Hi, I'm Shan Wu, and welcome to an Undercolor of Law hot take on Todd Blanche's excellent adventure, or his big day on a cross. So, Todd Blanche finally had a good cross-examination question or line of questioning. Blanche is the well-heeled former big firm attorney, former federal prosecutor, who was doing the cross-examination of Michael Cohen. Cohen, of course, is the former attorney for Trump, his so-called fixer. And Michael Cohen is an important witness in the Manhattan District Attorney's election interference case against Trump. Recall that in this case, the prosecution needs to prove that there was falsification of business records with the intent to further another crime. Now, both of those parts are so far looking pretty strong. The falsification of the business records was the fashioning of the reimbursement payments to Michael Cohen. That was for the $130,000 that he fronted to pay Stormy Daniels. And rather than those being recorded accurately as being reimbursements, they were recorded as legal invoices, fictitious legal invoices, because he wasn't actually doing any legal services at that time. Now, her silence was important because it was important to the campaign. And that's the part that bumps it from a misdemeanor to a felony, because it was just the falsification that would just be a misdemeanor. So to prove that there's a furtherance of the election fraud or interference part, that goes to what was the motivation for Trump doing this? Was the motivation only to cover up personal embarrassment or to keep his wife Melania from finding out? Or did it also involve trying to help the campaign, which brings it to the campaign finance violation? Now, for both of those pieces, there seems to be a mountain of evidence. There's paper evidence, there's testimony, and all of that establishes pretty easily, really a no-brainer, that there was a falsification of the reimbursements because they weren't called reimbursements. Now, on the motive part, just keep in mind, it's not an either or. It doesn't have to be that the government proves beyond a reasonable doubt that the only reason he did this was to prevent embarrassment versus the only reason he did it was to help the campaign. You can have a mixed motive. And actually, that makes a lot of sense, right? Because the more embarrassing it is, the more that Melania might have been upset, the same embarrassment, the same upsetness would cause voters to react badly as well. So just keep in mind that those are not the either or kind of defense posturing that you may hear about this. Now, what is very important that Michael Cohen needs to supply is the idea that the reimbursements being improperly or fraudulently characterized, that was directed by Trump. Because Trump can always claim that he had no idea this was being put in the accounting books this way. He's a very busy guy. He's president of the United States. He's running for president. Now, there's a lot of circumstantial evidence showing that Trump's quite the micromanager, especially when it comes to money. So it could be hard to imagine he wouldn't know about that. And circumstantial evidence is perfectly fine. Sometimes people think, oh, it's only circumstantial, but that's perfectly fine. It's just as strong as direct evidence. Now, the only direct evidence would be Michael Cohen talking about when he spoke to Trump, because a lot of times that's just one-on-one, the two of them speaking together. And that's why Cohen's an important witness. But he's not the only witness. He's not the entire case. But he is very important because he can supply that very persuasive link. So, what was the big successful line of cross-examination? And by successful, I just mean that it appeared to actually be a competent cross-examination, because a lot of it previously was just wandering around. Now, I don't know Todd Blanche. I've never seen him in court, but he has a very good pedigree. He's one of the most famous law firms in the world. He left that practice to represent Trump. He's a former federal prosecutor. But we also know that this is only his second trial as a criminal defense counsel. And that's very different than prosecuting cases. I know because I've done both. You have to really switch and get some experience switching sides. It's also possibly quite different than the sort of more highfalutin federal complex white collar crime cases he may have put together as a prosecutor. Not to mention the fact that he's probably severely handicapped by trying to please Trump rather than sticking to his own legal skills and strategy. But whatever the reason, thus far his cross-examination has seemed to me and quite a few other commentators as being not that effective. He didn't seem to have a theme. He was kind of jumping around. But nonetheless, this specific line of questioning he did was pretty good. And here's why. It focused on a particular phone call that Michael Cohen had testified about, in which he said he was calling Trump to specifically talk about the Stormy Daniels matter and the resolution of it. So that's really critical because that puts Trump's mind right in the crime. And Cohen's testifying to that. And Cohen had said that he knew that Trump was with his bodyguard, Keith Schiller, who's practically always with him. And so Cohen had called Keith Schiller so that he could talk to Trump about this matter. So the cross-exam was based on the idea of, is this true that you called Schiller to talk about the Stormy Daniels matter, or was it something else? So Todd Blanche's big gotcha moment was that there were phone records indicating a particular phone call happened, but Blanche wanted to point out that one was a very short phone call, and two, that Cohen may also have been speaking to Schiller, or maybe was only speaking to Schiller about receiving harassing phone calls from a 14-year-old. So the point the defense will have to make of this is to say that Cohen is lying about the real purpose of the call. Maybe he didn't even talk to Trump. He was only making that phone call to talk to Schiller, the bodyguard, about these harassing phone call issues. Now, the reaction to this has probably been predictably way overblown. So let's take a listen here, and then I'll talk to you on the other side and discuss what I actually think of the line of cross-examination, and more importantly, what will happen next? How will the prosecution deal with it, if at all? So first, let's take a listen here to my friend and colleague Ellie Honig's reaction, which was predictably kind of dramatic.
I don't think I've ever seen a star cooperating witness get his knees chopped out quite as clearly and dramatically as what just happened with Michael Cohen. I've certainly seen very effective cross-examinations of cooperating witnesses. I've seen aspects of their story cut into and called into question, but this goes to the heart of the allegation here, that phone call on October 24th, and it looks to the jury and to Anderson Cooper and Kara Scannell and Judge George Grasso, who are all in the courthouse, that was a devastating moment.
Now, just off the top of my head, I'd say that a cross-examination line of questions about a particular cell phone call, among many others, doesn't really constitute getting one's legs chopped off. Although Ellie really seems to be leaning kind of heavy into his organized crime prosecution background with that image. I also just have to include this one point because there was a great exchange that Ellie had expressing his dislike of the prosecution in this case, and maybe the real reason why Ellie can't stand the case. Take a quick listen.
Michael Cohen, so obviously and over the top, is consumed by hatred for Donald Trump and wants him in prison, is celebrating and is selling T-shirts, is outrageous. We sort of take it for granted because this has just been Michael Cohen's public persona for the last 5-6 years. But this should be a bonanza for cross-examination. I mean, you, with three former federal prosecutors here, what would you do if you found out the eve of a big trial that your star witness was selling T-shirts showing the defendant in prison? I mean, you'd have to think hard about dismissing the case. That is a major flaw in the defense.
Especially if he's Cheeto dusted.
Yeah.
That would be the...
Seriously? He would dismiss the case because of the T-shirt that Michael Cohen was wearing? Okay. Last point on Ellie, just can't resist this, is when Trump came out of court, he actually mentioned Ellie.
Well, thank you very much. I think it was a very interesting day. It was a fascinating day. And it shows what a scam this whole thing is. And I think that seems to be the way almost everybody, even CNN and MSDNC, they have quotes over here that are drop the trial. Ellie Honig, this is a statement he just made, would not have even charged this case. This case shouldn't have been charged, meaning it should have never been started against me.
All right. I'm not going to say anything else about that. Less surprising, perhaps, was the reaction of two of Trump's former attorneys here to the cross-examination. And you can take a listen here to their ideas about how important this cross point was, as well as my reaction to it.
Salvage this case. I'm not even saying it needs to be salvaged. Maybe it doesn't. Maybe the jury's ready to convict right now. Who knows? But how would you salvage this case, given what has happened to Michael Cohen on the stand today?
Grab the lifeboats. Maybe grab a misdemeanor if you can. This thing is imploding. And it's interesting, Jake. There's a great parallel that developed today. This case is going to turn on was the
that phone call in October.
Was the motive here President Trump trying to save his marriage or save his campaign? And now we have Mr. Cohen, who told this jury under oath, I called about Stormy Daniels. Now he's trying to hurt a 14-year-old child. So it's a really interesting parallel. What kind of fink goes after a 14-year-old kid? I'll get the Secret Service. You ever hear a call block? I mean, we get hate mail all the time. You just block them. I mean, this guy is a crumb.
And what do you think?
Well, I think, today's in the afternoon particularly proves the point. You can never tell a lie the same way twice, but you always tell the truth the same way every time. And I think Cohen got caught bad on the stand at the end, and I think, there's a lot of daylight there for not guilty.
Shan, what do you think?
The case is not imploding. If I was advising the prosecutors, I'd say rehabilitate him on a couple of points, including the phone call. They need to refresh his recollection to make sure that he can clear that up.
Yeah. Thanks to all of you. Really appreciate it. Let's bring in.
Well, as you heard me tell my fellow colleagues on that panel, the case is not imploding because of one question on cross, or even several questions on cross. I also just want to talk for a moment about this notion that you can always tell the truth in exactly the same way because that's the truth. But when it's lies, you tell it differently all the time. That's really kind of ironic because anyone who has ever undergone cross-examination or ever cross-examined someone knows that it's really easy to find inconsistencies when someone's had to tell the same event several times. In fact, most lawyers don't want their witnesses to have to keep telling that same story over and over again because you can't tell it in exactly the same words. Was it a big car or a large car, for example? When we're preparing witnesses, I don't want them to have given one statement to the police, then maybe a deposition, then grand jury testimony. By the time you get through all that, there are tons and tons of inconsistencies. You don't want your witnesses to have to give a whole bunch of statements about the same chain of events because invariably there is going to be inconsistencies, and that's what you try to exploit when you are cross-examining someone. So interestingly, when you apply this adage to Michael Cohen, this is a man who's obviously in past years been doing an enormous amount of talking about the same story, which is this case, the heart of this case. And yet, the core story he's been telling has never changed. I'm sure it maybe uses different words, different adjectives about it, but the details don't change in terms of what he was doing, why he was doing it, and who directed him to do it, namely his boss, Donald Trump. So it's actually kind of remarkable, given how much talking he's done, that his story has stayed very much the same. So let me deconstruct this controversy that was generated by this cross-examination a little bit. Let's take a look at the critical point that is being focused on during the cross-exam and see the way that the coverage is blowing this up, probably a little bit out of proportion. So let's first take a look at what was actually asked on the direct examination. So here's how Blanche approaches the cross. Question: when you testified on Tuesday that you had a specific recollection that 1 minute and 36 second phone call on October 24th was not with Keith Schiller, that you called Keith Schiller and he passed the phone to President Trump, you finalized the deal with Stormy Daniels and you said, quote, we're going to move forward. And he said, quote, yes, because you kept him informed all the time. That was your testimony, right? Answer: that's correct. Question: that was a lie. You were actually talking to Mr. Schiller about the fact that you were getting harassing phone calls from a 14-year-old, correct? Answer: part of it was the 14-year-old, but I know that Keith was with Mr. Trump at that time, and there was more than potentially just this. That's what I recall based on documents I reviewed. So, by the way, this is where Bill Brennan, you saw in the clip, Trump's former attorney, gets really worked up because he thinks that Michael Cohen is being very mean to the alleged 14-year-old making the harassing calls. Seems like a little bit irrelevant. So, on this point across, Cohen may have been slightly disserved by the way the prosecutor originally gave him the direct examination, which is the prosecutor might have tied this part of the testimony a little bit too specifically to the recollection of the exact time, the exact phone call, because there are a lot of other phone calls in which Cohen and Trump have these communications. But the prosecutor wanted to be very, very specific to this one, and it causes Cohen to sound like he's a little bit too invested in the certainty of that call. So Blanche then basically tries to question Cohen's recollection of how good that call is if Cohen isn't talking about the 14-year-old with the harassing phone calls. Now, Blanche here, you can see that wind-up. He keeps doing this. It's like a really long wind-up instead of just hitting a quick question, which is, for example, he could have said to him, "You didn't even talk to Trump on this call, did you?" And gets you more quickly into it. So it also was not particularly effective because Blanche, you can't see this in the transcript, but from people in the courtroom, Blanche apparently got really dramatic here and worked up and raised his voice, began yelling, and in some descriptions, his voice rose almost to the level of a shriek. Some observers felt that a couple of jurors might have been put off from that with some eye rolling. Generally, it's never very effective for the lawyer to be yelling at the witness. You should just make your point. Let the witness be the one who gets rattled, upset, not you. Okay, that's a stylistic point. However, what Blanche is trying to get across is that Cohen's just making this up, that maybe only called Schiller about the harassing phone call and never spoke to Trump about the Stormy Daniels matter at all. Now, it requires a little bit of work to get that from this line across, and to Blanche's credit, maybe he's going to sum this up in his argument. But the theory would be that Cohen knows he needs to tie things to specific phone records. So he knows what phone records exist because the prosecution has shown him these records. So he picks one that's in the right time period to say, oh, this is the very phone call that I remember. This is the phone call in which I talk about these specific things with Trump. So that allows Blanche to say, well, okay, then how come you didn't talk about the other part of this phone call, which was the 14-year-old? That's Blanche's whole point. Now, this is not that much of an important point because in closing, they don't need to have only this one call. There are many other calls as well. There's another problem here for the defense theory, which is, as we've heard, they want to make him out as being a liar. You hear some of the commentators talking about him like he's possibly the worst pathological liar in all of history. So, people who are pathological liars, who lie a lot, they don't react this way on cross. A real liar is going to react to being questioned by denying everything and just leaning into it. Instead, Cohen, particularly the courtroom observers, and you can even see this in the transcript, Cohen seems to be carefully thinking over the question and is allowing that there were two parts to the call, not just one, and he says to the best of the recollection, according to the documents he reviewed, which is the phone records. So no one knows exactly how it's coming across to all the jury, or if, different jury members may have different ideas about this. But based on my experience, I'd be pretty comfortable with the idea of a witness reacting this way to probing cross. Because to me, Cohen's coming across as someone who's trying to be accurate rather than a person who just makes up lies whenever they feel like it. Now, how's the prosecution going to deal with this? Well, I would expect them to address it in what's called the redirect, which is you get to go again on direct after the cross. A number of easy ways to address this. One, the prosecution can simply go back over this point and make it clear to have him reaffirm that definitely I talked to Trump about the Stormy Daniels matters here. They can also have him explain about not mentioning the 14 harassing phone calls. Frankly, it's sort of common sense, which was not that important to me many years later as compared to the issue in this case, which I lived with for years and actually went to jail over these issues. So it makes a lot of sense that Cohen would really remember the main point of that call rather than the part about the harassing phone call. And for that matter, he may have only spoken about that for a moment with Schiller before the phone's handed to Trump. Now, you're also hearing a lot of commentary about how, oh, it's impossible he could have had this important conversation in such a short phone call. Well, it's not that short of a phone call, particularly when you remember the kind of shorthand, kind of fake wannabe Goodfellas mobster kind of speak that Trump liked to talk to Cohen in. That's certainly not too short of a time for people who regularly talk to each other all the time to have a quick conversation for Cohen to confirm that this is what his boss wanted him to do. Actually, one of my Twitter followers suggested that what they could have done in court, or may still do, is say, okay, let's all be quiet for the minute 36, whatever it was. And you'll get a sense of just how long it is to wait in silence for that amount of time. So there's quite a few things that can be done to kind of address this point. And keep in mind also, whatever the prosecution does, is that the point of redirect is you don't want to highlight something that you think Cross was actually successful on. You just want to reaffirm a couple of points, keep the jury focused on the big picture. And the big picture there is going to be, well, what's the call about? It's about talking to Trump. And could there have been some other things discussed during this phone call, maybe with Schiller? Sure. Those things aren't as important as the main important point, which was Trump's knowledge about this. So trials usually are not won on a single gotcha kind of cinematic moment. You want to make good points on your direct. You want to make good points on your cross, so that you have material to weave together at the end in your closing argument or closing summation. So it still remains to be seen how this is all going to get woven together at the end of the case. And only the jury is going to get to decide whether there's a sufficiently good job of weaving to convince them beyond a reasonable doubt that there's enough evidence to convict. Or if they don't think the prosecution did a strong enough job of weaving this all together, in which case they will acquit. So that's the deconstruction of this big controversy. I hope that's helpful. And thanks for joining me. And again, thank you so much for all the comments. I try to read all of them and get to them. Really appreciate it because it helps inform what we're doing here. And we'll talk to you soon.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.